Hello and welcome to the Sidebar, presented by True Crime News, taking you inside the courtrooms of high-profile and notorious cases from across the country. I'm your host, Joshua Ritter. I'm a criminal defense lawyer based in Los Angeles and previously an LA County prosecutor for nearly a decade. You can find me on all social platforms at Joshua Ritter ESQ or at joshuaritter.com. We're recording this on Wednesday, August 6th, 2025. In this week's episode, lawyers for Utah mother and accused murderer Kouri Richins are complaining that there is too much evidence in their case. Plus, a mother facing a new trial after allegedly encouraging her son to gun down his former partner and the mother of his child. But first, a potential mystery man defense as a man on trial for his wife's murder alludes to a suspect that prosecutors claim does not exist. Today, we're joined by Misty Marris, an attorney and legal analyst you can catch on CNN, News Nation, NBC, and many other outlets. Misty, welcome back. How are you?
Hi, Josh. I'm great. Thank you so much for having me. I can't wait to dig into these cases.
Yeah, they're good ones. Some of them, we were talking beforehand, some of them we're very familiar with. We've been talking about Kouri Richins for a while now, but a couple of these other ones are kind of new to us and very... Is fascinating the right word? Is mysterious the right word? I don't know, but there's definitely some stuff for us to get into.
Yeah, fascinating. A lot of twists and turns. And I have a feeling, Josh, as these cases make their way through court, we're going to be hearing more and more about them.
Yeah, I think you're right. Well, let's jump in then. First, out of Liberty County, Georgia, a husband facing trial for his wife's murder and dismemberment is presenting an alternate suspect defense, pointing the blame at a person whom prosecutors claim does not exist. The beheaded remains of Nicholas Kassotis were discovered back in November of 2022 near a Georgia hunting club after her corpse was split into 4 pieces and scattered over a 3-mile area. It took investigators over 18 months to identify the woman, finally making a positive connection through genetic genealogy in May of 2023. One day after her identification, police arrested her husband, Nicholas Kassotis, in Pennsylvania, and he was extradited to face murder charges. Prosecutors claimed that Kassotis used his legal knowledge as a former Navy JAG officer to attempt to cover up his wife's murder before leaving the state. Kassotis was allegedly motivated by a $1.5 million judgment owed to his ex-wife, Heather Thomas, and Kassotis and Mindy were reportedly on the run at the time of her murder to avoid paying the sum. However, his defense claims that the couple were not running from the divorce settlement, but instead they were being followed by a mystery man named Jim McIntyre, who allegedly controlled the couple's finances. The state claims no such man exists. However, Kassotis' defense intends to introduce statements made by the defendant and his deceased wife that corroborate the mystery man's existence. Since the costly divorce and Mindy's death, Kassotis has stayed busy matrimonially, wedding a third wife, Samantha Colesmith, with whom Kassotis was having an affair at the time of Mindy's death, according to prosecutors. Trial began earlier this week, and we will keep a close eye on how this one develops. There was a lot going on there, Misty. First, can you describe for listeners just kind of this concept of an alternate suspect, how that works? Are they just allowed to bring in anything they want, or does the judge have a say in all of this?
Yeah, Josh. So it's interesting. I don't know if you're a fan of the movie The Fugitive, but this reminds me of the one-armed man, like we were saying. And so an alternate suspect defense it's a defense strategy, but there's a couple of hurdles to actually bring that defense into the courtroom. So it's important to make the distinction between alternate suspect defense versus a defense where you question the investigation and say that perhaps police did not do their work, that there were other people who could have committed the crime and they have blinders on for the defense. That's one defense that you see play out in almost every criminal case, really questioning the investigation and what happened and the failures of investigators during that time. But this goes a step further than that. It's when the defendant actually points to another individual. So they point to another person and say, it wasn't me, it was them. So of course, because this is relating to another specific individual or group of individuals in some cases, the judge first is the gatekeeper about whether or not the jury will actually even hear that defense. And what the defense has to show is that there's actual evidence of motive, means, opportunity to commit the crime, that it's not speculative, that there's real probative evidence. We hear that all the time in criminal cases, probative evidence, evidence that has to do with the specifics of the case that points to this individual. So there is a real hurdle to even getting this defense into the courtroom. But what I find fascinating about this case, Josh, is that it seems like the defense actually overcame that initial burden, which happens outside of the presence of the jury. This is all the pretrial motions that you see before the case actually gets to trial, because in their opening statement, Jim McIntyre was the centerpiece, right? So now the jury has heard about this individual, and what the defense has said in both pretrial motions and now in the opening statement is that during the time that Kassotis and his wife Mindy were on the run, that there was Jim McIntyre. He was chasing them. He controlled their lives, controlled their finances, and he had actually told other people about Jim McIntyre. Mindy had told other people about their fear of Jim McIntyre. And so the judge let it in on that theory when prosecution says this individual doesn't exist. So it's going to be interesting to see if there is more and what that really is about as far as the evidence that the defense was able to show to even raise this in the first place.
Yeah, it's fascinating. And it even is got another wrinkle to it, because it's not kind of your traditional alternate perpetrator, third party culpability sort of defense where they're saying, hey, it wasn't me at all. It was this other person. He's almost saying, hey, the reason we were on the run had nothing to do with what the prosecution is saying why we were on the run. We were on the run because this guy, McIntyre, told us to be careful and to look out, and people were after us. So I don't even know if they're trying to say McIntyre's responsible for her death, or these mystery agents out to get them that McIntyre had warned them about. That's who did it. It's kind of one of those, you know, like you said, judges are supposed to be gatekeepers and keep this kind of throwing spaghetti against the wall, see what sticks sort of a defense. But that's what it's shaping out to be, at least in my view.
Yeah, I think we're going to have to see where it goes. But Josh, to your point, here's what I wonder. And you're right. They're using it to cut off this idea of the motive, right? The motive, as far as prosecutors are concerned, is that there's this gigantic over $1 million judgment, and that they're running from from collectors, basically his ex-wife, from being able to collect that judgment. And now the defense has raised this. Well, no, there was this mystery individual, Jim McIntyre, who is basically chasing them around and controlling them. Okay, fine. Now, what does that mean when it comes to actually establishing more? So I think it's important to tell the audience, the burden doesn't shift to the defense. The defense is still raising reasonable doubt, right? The reason to bring up this person, even though they were able to raise this alternate suspect defense, it doesn't mean that the defense has to prove that Jim McIntyre did anything. Right. They just have to raise reasonable doubt. And that's where they're going with this narrative. Now, that being said, I wonder, because we don't really know about what testimony is going to come in, statements relating to this person that apparently he and Mindy told back when they were on the run that this was the reason. I don't know what that's going to play out. Is it electronic? Is it going to just be testimony? But here's my question. How do you establish how that all fits into the puzzle unless he testifies, right? How do you establish who this person is and how it really impacts the case unless he testifies? Because, and I don't think he will, by the way, but the burden doesn't shift, but almost in the mind of the jurors, from a defense perspective, you take a risk going this route and pointing to an individual if you can't show them what it really means and how it fits into the broader case.
Excellent point. You're right. If he really wants to give it a go with this defense, it seems like the best person to present that would be him, to explain exactly who this mystery man is and why they were on the run. One more question about this motive thing. From the prosecutor's perspective, I'm having a little trouble understanding their theory here as well, because they're saying he was on the run. They were on the run. There was this $1.5 million judgment from a divorce. So him and his current wife, they take off. They're on the run. So then he kills her? Like, where's the ... in between here? What is the motivation for being on the run have to do with killing the current wife? Now, I know they are also saying he was having an affair at that time. And they're also saying that he then married that woman he was having an affair with, which, okay, now it's starting to make some sense to me here. But do you understand the disconnect, or am I missing something between the being on the run to evade a civil judgment, which, by the way, isn't necessarily make you a fugitive, and then I killed my wife? You follow me? Yeah,
I do. And there was a couple of other things that I found to be interesting that I'm wondering how prosecutors are going to put together. The ex-wife, where there's a big pre-trial issue about whether or not she would be permitted to testify regarding the judgment. And the judge said, I'm inclined to let her do it, to let her take the stand. They didn't contact in 3 years. So there's this other time gap between the ex-wife and contact with the defendant that puts a big question mark in there. And then, to your point, we're talking about a horrific, grisly murder involving dismemberment, right? So prosecutors are saying, here's the motive, but how does that motive connect? And by the way, when we were just talking about how the defense might be impacted by the third party culprit or third party suspect type of defense, prosecutors also take a gamble when they look to establish motive, and they present 100%. Motive right out the gate because they don't have to. And by the way, juries love to hear it. We all like to hear it, especially when it's a husband and wife. You want to know why something so horrific like this particular case and the facts of this case could happen. So prosecutors want to give that narrative and story to the jury, but you also take on a potential issue if that motive is shaky or can't be established, because even though it's not going to be an element of the crimes as they're charged, not going to be on the verdict sheet, it's still something the jury is going to stick to and look for and be analyzing whether or not it has been established. So I agree. There's some holes in there. I'm wondering if we're going to hear about Mindy having some kind of money or insurance policy that he would have been entitled to as time goes on that links that financial piece. And maybe that will be where it comes to fruition. But I agree. It's also a civil judgment. There's a couple of things that just don't make sense. That being said, in the first day of testimony, we heard a lot about the investigation. There's some purchases at Home Depot and a knife that was purchased, and a lot of that connecting back to the defendant not looking so good just from optics right from the beginning.
Yeah, that's an excellent point, though, you make about motive. Prosecutors don't have to prove it. They like to have it. They like to give jurors something to hang their hats on. But when you don't have to prove something and you still offer a theory on something, I'm sorry, I don't care what you instruct jurors on. They're going to feel like that's something you need to prove to them. And if they feel like you didn't prove that to them, they feel like your theory of motive is not all that reliable, they might call into question the entire case. I don't know. We'll see if that happens here. Last question on this, though, and this is just, I want to get your take. He's got a legal background. He was a JAG officer. He's got a law degree, and they have tried to point towards his prosecutorial experience, the prosecution has, saying that that gave him some advantage in his ability to know how to evade capture and how to clean up a crime scene and how to dispose of a body, which first, as a former prosecutor, I took offense by. Does that mean I'm better at committing murder because I've had this job? I don't know. But what is your take on that? Do you think that the fact that he has this legal background advantages either the prosecution or the defense or neither one?
I think I know where prosecutors are going, and it speaks to that idea of needing an explanation for why somebody would commit a murder that's so grisly. Because even if, say, hypothetically, you believe that, just say that there was an affair involved, he gets married to the woman after. So this is about a romantic relationship or the money or whatever you're going to believe. But I think that the affair leading into a marriage and some of the evidence that's coming out about, purchases that were made shortly after that just doesn't seem like the grieving husband would be making, that was really more about the next relationship. So you really need to tie that all together. And why is this murder something that's so horrific? Why is there a beheading? Why is there dismemberment? And I think what prosecutors are going to say is, well, because that makes it harder to identify a body, to put together the pieces for an autopsy. I don't know if that really lands or helps, that this specialized knowledge is necessarily relevant in this particular case. We'll see how it's laid out. I would say maybe the defense will take an alternative stance and say, well, prosecutors are pointing to these things where they say it's like he's caught red-handed. He made these purchases. As a prosecutor, if he's so specialized and he's so savvy to how to commit the perfect murder, would he do any of that? Would he do that and then murder his wife? So I think you'll probably see competing narratives when it comes to that. But something I do think is interesting that you pointed out is these theories: alternative suspect, the money, the $1.5 million judgment, the experience as a prosecutor. All of those things on both sides were laid out in opening statements. So now it's out there. And the question is, can you deliver on it? Because I really think no matter what you put out there in the opening statement, if you don't come through with evidence to support it, whatever it may be, that is a glaring hole in your case that the jury will notice. So we'll have to see how this all plays out. But I'm wondering what is actually going to be delivered on some of these theories that sound really salacious at the gate, but where's the evidence that backs it up?
You're very, very right, especially for the defense. Usually they need to play it safe because they're playing defense, and they should probably wait to see what the prosecution does to pivot. But when they really lay out a aggressive and broad plan in opening statements, you're right. We kind of want to see if they're able to cash those checks. That case is currently ongoing. We will keep an eye on it for all of you. Let's move along to Pensacola, Florida, where a mother is facing trial for a second time after allegedly encouraging her son to kill the mother of his child. Sheila Agee is facing charges as a principal in the first-degree premeditated murder after her son, Keith Agee, fatally shot teen Brooklyn Sims, who was the mother of his 2-year-old child. The fatal shooting occurred in a Home Depot where Sims worked with Sheila Agee, and prosecutors say Sheila encouraged the murder, even providing the address for the shooting to her son. Keith Agee admitted to shooting Sims, claiming the shooting was retaliation for an STD he had contracted from the victim, and was later sentenced to life. However, Keith's conviction didn't preclude Sheila from charges, with prosecutors alleging the mother was the catalyst in Sims's untimely death. Sheila's first trial ended in a mistrial after disagreements in the deliberation room led to racially motivated arguments, eventually escalating to threats of physical violence, raising concerns about the safety of the jurors. It remains to be seen if cooler heads will prevail in deliberations this time around, but we will be watching this one closely. Amongst the evidence that prosecutors have presented in this case, Misty, to prove that Agee, the mother's role was some text messages, one of which she allegedly sent to her son shortly before the murder that said something along the lines of, "You're an MFing B word if you don't kill her." How much of that, though, is tough talk? In other words, seems to me, we hear a lot of people talking tough. A lot of people, get intoxicated, say, "I'm going to go do this. I'm going to go do that. You should go do this. You should go do that. How are you going to stand around and take this?" There seems to be a pretty broad jump there to make from tough talk to saying, no, in fact, this was conspiring and planning a murder. Where's the line?
Right, because she's charged as a principal. She's not charged with committing the actual murder. And so what the law requires is that she had intent to commit the crime. Her physical presence is not required, but there has to be some sort of action in furtherance of that intent. And we usually call that an overt act, something more than just words. And I think you raise a really good point, because this case is based on those text messages. In fact, I was following the testimony of 16 witnesses who have testified, many of them investigators, some that were there at Home Depot on the night of the shooting, who said they observed odd behavior, but nobody with any additional information about how she was involved in actually planning to commit this murder. So these text messages are really ruling the day. And we know, because this is the second time around, right, Josh? So we have more information about what's to come, that what the defense argument relies upon is that she and her son spoke in these ways that maybe some families wouldn't find to be the norm. But they did communicate with this type of, as you say, tough talk. And it's not that this was a call to action. This was just the way that they communicated. And I think what we're going to see is comparisons among these text messages. Now, it's going to be a jury question as to whether or not that overt act or that action in furtherance of that intent to conspire to commit this crime is enough. And then what does it become? It becomes an appellate issue, right? But it's going to be the jury who will make that factual determination about whether or not those two prongs, first, the intent to commit the crime, second, an action in furtherance of that intent, are actually fulfilled by the prosecution's case.
Yeah. You know, listen, as a prosecutor, as a former prosecutor, I certainly appreciate aggressive prosecution, thinking outside the box. I certainly don't feel that anybody should just be given a pass just because you got a conviction on one person. But this case does trouble me a little bit, because you do have a conviction. You have a conviction on the trigger person. You have a conviction on the one who actually committed the murder. And when you start to expand that net and go after other people who took part in it, I feel like you need to really bring a strong case. Maybe they have it here. I mean, they've already gone through one mistrial, but maybe they have it here. But I also feel like they might be getting a little too aggressive. But I want to pivot to the jury issues in this case. The prior case ended in a mistrial. There was allegations, first of all, of one of the jurors reportedly doing crossword puzzles during trial. Another juror complained about fearing for their own physical safety. You ever seen the wheels fall off of a jury like this before? Is there any way to recover from that? How do you prevent something like that from happening?
Yeah, this was actually interesting that a mistrial was called based on these particular issues. First, there are rules in every jurisdiction. Actually, we were just grappling with this during the Harvey Weinstein trial. We were talking about a juror who said that they were fearful because other jurors were aggressive in the jury room and said they were going to follow him to his car. And the judge made an instruction to the jury, but did not call a mistrial. To the extent that there are jurors who are disruptive or not participating, there are ways to eliminate those jurors from the jury pool. And as you know, Josh, it becomes a lot more difficult once the jury begins to deliberate, because then eliminating juries from the jury pool for those types of reasons could create significant appellate issues. So here, it seems that it was significant enough that the judge actually called a mistrial. That is unusual. You would generally see a progression before a mistrial was called when you're talking about issues that are not necessarily relevant to the case. It's not like misconduct. Somebody's trying to bring in news articles from something they read, right? Which is a very clear-cut issue about how to handle a juror who does something like that, which goes into that area of misconduct, posting on social media. We see that type of stuff all the time in this day and age. But here, this was a very unique issue. And I think the only way to combat it is in jury selection, to be conscientious about who you're putting on that jury. That being said, you just never know what happens when you get behind those closed doors. But I can guarantee you nobody wants a mistrial again in this case.
Yeah. And one of the things that has always frustrated me the most is when you see these cases end because it does look like some juror got on there that really doesn't have a place being there, doesn't belong there, had these biases that they brought in. I'm not even saying the crossword situation, it goes to my example here, but I always think Why then are we rushing that jury selection process so much with attorneys? Why do judges give them such little time sometimes? What a lot of people don't realize, in civil cases, they seem to have almost unlimited time. In criminal cases, attorneys are oftentimes limited to 20 minutes to speak to 40 different people and keep it moving, counsel. And they act like it's this inconvenience to allow the attorneys to speak when you end up with these types of jury issues down the road. But that is my little soapbox for the afternoon. I'll leave it at that. Let's move on to our final case here out of Park City, Utah, where defense attorneys for Kouri Richins will get a look at the prosecution's upcoming case after a staggering amount of evidence demanded intervention from a judge. Richens, a Utah mother who penned a children's book about dealing with the grief of losing a loved one, is charged with fatally poisoning her husband with fentanyl. According to prosecutors, Richens was financially motivated to murder Eric Richens and is facing a separate trial for a slew of financial crimes for her alleged pattern of unlawful activity in the years leading up to her husband's death. Recently, Richens' defense has become overwhelmed with the sheer amount of evidence in discovery, which has reached upwards of 11 terabytes of data. Seeking a solution, Judge Richard Mrazek ordered prosecutors to present a draft of their witness list and exhibits for the murder trial to narrow the scope for Richens' defense. This list is due at the end of October, with another pretrial conference related to the data set for December 5th. Meanwhile, Richens has been repeatedly denied bail and will remain behind bars until this case sees trial, likely sometime in 2026. Misty, I guess my first question for you is, how much discovery is too much? We live in modern times. We've got modern problems. I remember when I was a prosecutor, it was a while ago, but it doesn't seem like it was all that long ago. I would hand over a stack of CDs to the defense and they would act like they were overwhelmed by it. But I'm talking about now people are handing over stacks of hard drives. 11 terabytes of information is just so much. Is it too much? What are we dealing with here?
I guess for me, I saw 11 terabytes and I've been following this case and I saw the arguments. And as a defense attorney, I thought 11 terabytes, that's not that much. And that's really because you practice in federal court. You know how much gets turned over in electronic discovery and evidence. It's so much now. Just give a little context. Koberger had, I think, 68 and Diddy had 90. Oh, by the way, every defense team in those cases also said the same thing. And it's really more about having time to go through it and ensure that you have the ability to raise the right arguments relating to whatever prosecutors are turning over. Because remember, what prosecutors are turning over, not all of that necessarily makes it into trial. And there's a lot of evidentiary issues that you deal with before you ever get to the jury, and you need to know what you're dealing with. You need to know what prosecutors have and what they intend to use. So I agree from the defense perspective that it's more about figuring out a process and timing to go through all of that evidence. But I don't know, for me, I want to know every single thing that's out there to the extent that it might impact my case. And you know, prosecutors, as a former prosecutor yourself, you're not just turning over evidence relating to the case, you also have to turn over exculpatory evidence. So there's a lot of information that comes in a case that's electronics heavy. And I think here, because this is not just a murder case, and I'm not saying a murder case is simple. Murder cases are not simple. They're complex. But remember, there's also all of these other counts relating to financial crimes, which is document heavy. There are text messages. There was a book that was written that she wrote about grief. So you're talking about everything relating to that process, not just the final product itself. I'm not surprised to see a tremendous amount of discovery in this particular case.
Yeah. I want to talk about the judge's proposed solution here. He says he's ordering the prosecution to create their witness list, then to outline which exhibits will be used with those witnesses, and therefore that will kind of give a roadmap to the defense. Now, I think it's clever. I think it actually puts the prosecution in a little bit of a position, because now they kind of have to show a roadmap for their entire case to the defense. But if I'm putting on my defense attorney hat here, I'm thinking to myself, that's great, Your Honor, but that's not enough. I don't need to know what the prosecution plans to do with this evidence. I need to know what I plan to do with it. And I need to go through all of it, because what's important to them might not be important to me. I'm looking at this evidence in an entirely different lens than the prosecution is looking at it. Therefore, it's not really about them telling me what they think is important. It's about me having the time to go through it. And you gave me 11 terabytes worth of stuff. I need the time to go through it. But what are your thoughts?
As a defense lawyer, the exact same thing. I need to look at everything, because that's great that certain exhibits are going to go with certain witnesses for the prosecution, but I don't know what else is in there in order to see what I might want to cross-examine. I might want to call a witness based on other evidence. You're absolutely right. From a defense perspective, is it helpful from the process of potentially, okay, we'll start there? You still have to go through every single document. So again, it's more about having the time, and generally that the arguments that are made from the defense perspective, you have to show why you might need more time, how many people are on your team, the resources that you have. You know, when you're talking about defense teams, sure, you can add lawyers to a defense team, but by the way, every single person that you add costs more money, right? So there's all these considerations about how you round out a team and how you get through all of that information in time for trial. And generally, Josh, what happens is you see these cases get kicked back a little bit, or more time being extended to the defense. And as we know, as defense lawyers, I'm sure you've experienced this. I experienced it in New York, probably experienced it in California. Sometimes you're pushed regardless. You're pushed regardless to keep on a timeline and to get it done. But I agree with you. It doesn't seem like a sufficient resolution from the defense perspective, but it does sound like an effort to kind of balance the interests of everybody and maybe have a clever solution to a problem that exists in almost every single case now, with just the sheer amount of electronic evidence that's generally in these types of cases.
Yeah. And to your point about the sheer amount of electronic evidence, we're not saying that all 11 terabytes is even relevant.
Totally.
It's just stuff that happens to have been collected during the course of this investigation. But that's the problem. They don't know if it's relevant or not.
Right. And Josh, that's really it. You hit the nail on the head, because, and I get this question all the time. Everything that's exchanged falls into this bucket of, okay, evidence that's collected during the time of the investigation. Then the next inquiry, is it relevant? Then the next inquiry, is it even admissible? And those are different benchmarks and different arguments that you're going to raise, which is, to me, I want to know everything. And every defense lawyer wants to know everything, because there's nothing worse than having something in your possession and not knowing about it, and then it could have made an impact at trial. I mean, that's a horrible situation to be in.
Yeah. My question to you is this problem just going to get worse and worse as we go on in time and continue to compile electronic devices as just a people, as a culture? Because it used to be years ago, you'd arrest somebody, maybe they had a phone on them. That phone didn't have all that much information on it. Maybe that person had a computer that was important to you. Maybe it wasn't. But nowadays, to your point, investigators go in and they are seizing phones. It might be multiple phones. These are smartphones that are basically computers themselves with terabytes of information on each device. Then they go through the house and they're collecting laptops and computers and all sorts of other electronic devices and hard drives. I'm thinking about the Rex Heuermann case out of New York, where they went through several times. I think they collected dozens and dozens of different electronic devices that we all continue to carry with us through our lives and compile more and more of in each of these cases moving forward. As long as police are getting warrants for that stuff, they're going to have that turned over. They're going to have to turn that all over to the defense. At a certain point, it seems like it's going to become just unwieldy and too voluminous for cases like this.
Yeah, I think you're absolutely right. The volume will continue to go up as people live their lives electronically. The electronic footprint has become the most critical part of almost every single prosecution that we see and the defense, right? It's critical to every criminal case, it's critical to every civil case. Electronic footprint matters a lot. And because of that, you're talking about all that collection and the volume and the need for courts to maybe look at the realities of what that process looks like from a defense perspective. But those are also the most critical pieces of evidence in the case. They often can make or break a case. They become the most important and most valuable evidence. And so you need to have the time to go through it. I am not a technology person, but I do know, because I have those people in my life that I work with. Now, the development of programs to deal with this stuff, that's the next step, I think, for the legal field, because again, even in cases that aren't, we just named a couple of high profile cases, Koberger, Diddy, everybody's following those cases and the tremendous amount of evidence. But I would say in a lot of federal prosecutions specifically, as the defense, you're getting that volume in cases that aren't even high profile. You're getting that volume of discovery in cases that nobody would know the name of, but it's kind of the norm in the discovery process at this point. Just the sheer amount of information that's found during the investigation, turned over, and needs to be analyzed.
Yeah. Well, a problem I don't think we're going to solve this afternoon, but Misty, I so appreciate talking to you about these things. Thank you so much for coming on. Where can people find out more about you?
So go to my Instagram, Misty Marris Esquire, my Twitter, Misty Marris, and Josh, I did it. I just started a TikTok. As you can see, this is why I'm not the electronics queen over here. But yes, Misty Marris on TikTok.
Fantastic. I love it. I will follow you. I'm your host, Josh Ritter. You can find me on Instagram and Twitter at Joshua Ritter ESQ. And if you want to hear my thoughts and coverage on even more true crime cases, you can also check out my brand new YouTube channel, Courtroom Confidential. And you can, of course, find all of our Sidebar episodes wherever you get your podcasts. And we would love to hear from you. If you've got questions or comments you'd like us to address, please tweet us your questions with the hashtag TCN Sidebar. And thank you so much for joining us at the True Crime News Sidebar.